Excellent. Red means stop traditionally, when I think. So I'm not in support of this bill as inexpedient to legislate. I'm going to go and tell you a little story about a personal experience that I have with a neighbor who passed away who had an autistic child. Title 4D grant money, which the state is clearly addicted to, is a reimbursement for the management of child support and services of such. One of those, some of those stipulations that they can apply for grant money and should be guided by are to encourage marriage, nuclear family, and to get off of welfare services. I think this is Title 4D 601 or 606. I'm not exactly sure, but I can get that to you. I have it written down. So what happened recently, within the last 6 months, is a gentleman at my apartment had 2 children, and one was autistic. And he would go to the pool every day with them, and a product of a divorced planned family. And he ended up dying. And we're not sure if it was a suicide or if it was just a broken heart. Very healthy, went swimming, good shape, and was not a smoker. And then I saw him the day before with his older son, who's in high school, talking as they would walk in the back of my complex. And they were talking about high school, and I've talked to him. They're very friendly. He took very good care of this child. And the thing is that he was not the primary care person or parent. And so what we see is that what I suggest the Senate do to kick this back is realize the actual dynamics of family, current family right now. And what we have are incentives through child support, where statistically we should run a study. You'll find 70% of all divorces are initiated by a woman, and then they get primary custody, and then they also get the child support. Now, child support is a tax-free money, and it's incentive. It's tax-free. So to extend this, I see how it's trying to restrain, but to extend this above and beyond, so the post-secondary school, that's a burden to the other parent when really we should be providing those services in alignment with Title 4D grants and such, so that people are able to get off of government assistance and therefore would not need child support. And that's pretty much my statement on that. Yeah, we need to do a study on the actualization of divorces, parenting cases by gender, because you will discover that there's gender bias, and that is causing a lot of problems in the family. And it's like giving an incentive to one parent, typically the woman, to break up a family, because especially in autistic families, and the story that I told you, they want more free time. So they look at it as, wait, hey, I'll get a paycheck. I will have this kid, my child will be out of my care, because it's very difficult to raise an autistic child. Most people are blessed with children that do not have a physical or mental disability. So you'll see that they're kind of like separating. One parent's looking at it as, hey, I can get free tax-free money and I can get a break from the children, go off, date, find, and run away from my problems.
Thank you very much for your testimony, Mr. Tanguay. Are there any questions? Seeing none, thank you. Are there any other members of the public that would like to speak to House Bill 1282? Okay, seeing none, we'll close the public hearing. Robert Tanguay.
Excuse me. I got it right this time. Robert Tanguay, father of Ethan Walden and Robert Joseph Tanguay, my children, which I have not seen in over a year because of the issues within the family courts, fraud, injustice, lies, and also with the lawyers. I'm in support of this bill. As Dana Albrecht said previously here, what I would take from, though we don't agree on everything, is to bring peace to the family. That's what this bill attempts to do. I do have a couple recommendations, and then I want to go a little bit in depth at the current situation of the family courts and the way not just New Hampshire, but the entire country is looking at the familiar unit. Specifically, if you would take note of page 2, you're looking at 2 at the bottom, subparagraph 1. They say RSA 173B. 173B is unconstitutional via Article 15, right of the accused, is being contested in the Supreme Court right now with the Attorney General and the Supreme Court.
Wait, Mr. Tanguay, I'm just looking at this. It looks
Yes.
like it wasn't amended by the House. So I have the copy as introduced.
That's what I have as
Okay,
introduced.
because you said page 2, line 23. Okay, I see.
On some good old fashioned legal pleading paper.
Okay,
So
Thank you.
173B is, now I'm not saying domestic violence is correct, but it's a crime. They call it an act in 173B, but a pickle is still a cucumber. A crime, if you call it an act, is still a crime. Therefore, it has to go through due process. 173B removes liberties such as parenting, money, time with your children, freedom of movement. You can't have without due process. No lawyers, if you can't afford one. No rules of evidence, hearsay, and in my specific case, known physically and mathematically impossible findings of fact, fraud. So you got to remove 173B, and then this is very important. RSA or Chapter 546, made in 1955, is the Uniform Civil Liability for Support. It was updated in 2014 and 6. I'll go into that a little bit more, but basically what it says, if you go to section A6, wealth shall be considered assets are wealth in determining child support. So what we need to do is, instead of having 173B in there as abuse, because it goes into saying unpredictable work schedules or cases where there is evidence of abuse as defined in 173B, which is unconstitutional. Scratch that and say, or special circumstances such as RSA 546A5. And that will allow them to determine wealth. And the whole goal of this chapter is to, and it's the founding chapter, which is acknowledged, is to make sure that the children have equal living situations. So when you break up a family, you bring a child, and a child goes somewhere, and a lot of times that's determined, even though it's not supposed to, by 461A, parental rights and responsibilities. It goes to show, the kid ends up with the person who has the house, and then the other parent, which is me, kicked to the streets for no reason, is basically bringing them to Burger King or Chuck E. Cheese and having to pay child support, tax-free money. Wealth shall be considered. It says shall be considered in there. The judge has no jurisdiction. What we need to do is come up with laws that determine guidelines for the determination of wealth, because you have alimony and then you also have child support. Alimony is well settled, child support's not. So now I'm going to go into the family courts. Family Division, 2005, came from a test pilot program. Family courts in 2011. We don't know, family law is not settled yet. This is how it needs to be figured out. Because the family is an asset. The family is an intangible asset. The family name, my name, Tanguay, is a piece of intellectual property. And that's how you get defamation. So if someone lies about you and says some things about it, they're defaming your name, your last name, my children's last name, because they took them. And this was a planned family. So when someone breaks up a family, The way we need to be drafting our laws to lock and stop the bias in the courts is they have to look at it as the person is breaking up the family. There is not a no-fault divorce. A no-fault divorce is unconstitutional. You are breaking up a family. You are causing damage. You are torting. You are saying, I don't want to be with you. And this is typically because loss of attraction. A woman can go, in most cases, they can go post on Facebook or Instagram, and they can go and acknowledge, and then some guy will come move in. And how this actually works out with child support is that then when the two parties move in, right, all a woman has to do is, right, I'm single, come move in. They move in, collect child support, maybe they have other children, but the child support follows wherever the money goes. And then in this specific case, in my case, without stating names, the person that she went with was in a family with one child, then had a child. So that person was getting assets because they were paying tax-free money, child support, to the mother of the other party, right? It goes in, right? They're building up assets. They have a divorce. They split it. But then now this mother has 2 child support payments and an alimony payment. And it's causing incentive. We need to stop the incentive and look at it like, hey, we don't want you to get a divorce. You should work through this. You made a covenant to have children, and you made a specific choice to create children. You cannot simply split that up. And then that goes into divorce too. So just to reiterate, we need to go over 546B because these matters have already been decided. Child support was created in 1935, I believe. Okay? Wasn't updated until like the early 90s, and then 1996, 2001, 2005. They kept updating it federally because of all these issues that we're having. We're giving an incentive for people to split up families, which is against Title 4D. Children do best with both parents in a nuclear family. We need to save that. And then the person who is deciding to break up that family is abusing the children and abusing or hurting the other party, unless it's mutual. And it's rarely mutual. I beg to keep my relationship because I grew up without a father. I know it's a lot. If you have any questions, I'd be very happy to answer them.
Thank you very much for your testimony, Mr. Tanguay. Are there any questions for Mr. Tanguay?
Thank you.
Seeing none, thank you.
RSA 546A.
I
Thank you.
got it right here. A5. Okay, Robert Tanguay.
Thank you, Robert Tanguay here. I am opposed to this bill. There's something I want to draw attention to the Senate. And we have repealed the dividends tax. That equates to about $136 million a year. It was pushed right through, which extends beyond the entire judiciary's budget of about $109, maybe $112 million a year. So we need to really have more oversight. But these orders where the children's placement are all court orders. And it says in this bill, you know, we're giving out $1 million to the DHHS without really any specifics on how to do it, how to use it. And then you're saying you need more judges, but we repealed very quickly interest and dividends tax, which, by the way, Justice Hans Marconi of the Supreme Court's husband has a financial disclosure where he has pecuniary interest in where he would make more money off of the dissolution of the interest and dividends tax. That was disclosed too. So you can look that up at the Secretary of State. And then in conjunction with that, we also passed a law which is quite peculiar, which gives the Supreme Court, this is all within the last year, the Supreme Court the ability to handle the financial disclosures by the judges. So Now, are those financial disclosures not going to be on the Secretary of State's website? Are they going to be hidden in the catacombs of the Supreme Court? What we really have here in the state of New Hampshire and across the country, but specifically in the state, small, powerful state of New Hampshire, is we have a judiciary, which the three branches of government, the judiciary is this real big triangle, and it has more power. They can choose anything, including what happens to your children. So if I was to happen to sue the state and get $1 million, it doesn't matter because the family courts still have unlimited discretion. And then when they violate the laws that we enact, cause fraud, they send you up to the Supreme Court, which is now violating, I contend, federal rules of civil procedure. So we're just not able to get justice. So while I do want these poor kids who have gotten the unfair shake at life, they didn't ask for any of this. It really starts in the court and making sure that the facts are correct in the court. Because my biggest fear is, since the mother's not that horrible, though I contend she's abusing my children, is my children being put into placement. So I would rather me suffer than my children suffer. That's the biggest fear. Like, just imagine not living with your parents, what that does to a child. So with that being said, I don't find this expedient. I think that we need to really focus on the family courts, making sure that the judges are telling the truth, the lawyers are telling the truth according to the 0311:6, and that there is not retaliation against pro se litigants, which has happened in many cases. Thank you so much.
Thank you very much for your testimony. Are there any questions for Mr. Tanguay?
Thank you.
Seeing
Thank you, Madam Chair and distinguished members of the Senate. My name is Robert Tanguay. I am the author of New Hampshire, Oliver Twist. And this bill, which I oppose, reminds me of New Hampshire, well, Oliver Twist, and orphanages and children being taken away from their families and used. I mean, basically, you won't see rich people's children getting taken away. It's only the poor. That's the way it's been since the beginning of time. This bill gives, and it is a bill, because there's a $3 million price tag, number 5, given to the Department of Health and Human Services to retain jurisdiction over children, which are, I guess, special needs. And I just don't think there's any reason for this. Now, I want jurisdiction over my children, whether they have special needs or not, because it's my God-given right. A parent would be needed to be incarcerated to be removed of their rights according to the Constitution, which would mean criminal charges, or they would have to submit to a plea. They would have to be judged by the jury of their peers or submitted to a plea. We need to fix our family courts. This is akin to political patronage, which is not allowed by Title 4D. It is the state is supposed to, including Matt Hayes, who spoke earlier, and I'm not angry at any of you guys or anybody. I'm just trying to be focused. The state is required, and I will send these laws to you. I've written them down, to create a system to find out fraud and political patronage, because that's what we have. Our justice system, as much as we try to make it perfect, is based on our biases, inherent political patronage. And that's what these laws are. And we try our best. But it all comes down to, there's a contract which I'm going to send you guys. It's called the Expedited Child Support Program. It was signed a couple years ago to expedite the granting of child support, and has promulgated to all parenting cases. They want to issue child support immediately. Within 6 months, 75% of all child support orders. And within 1 year, 90%. That's their guidelines. This is from, I believe, the Department of Justice to, and it's signed, to the AOC, to the family courts.
Mr. Tanguay, this bill is about extending court jurisdictions over persons receiving special education. It has nothing to do with child support or anything like that. So I'm wondering if perhaps you've got some bills maybe mixed up a little bit.
Senator Carson, I appreciate that. I don't. It's all connected. You have to look at this as a big scheme. The court retains jurisdiction and it's connected so that they can connect child support and get money from Title 4D, federal money. So they're asking for more money and they're taking jurisdiction. I don't want them to have jurisdiction over my children or anybody's children unless the person's incarcerated. So this bill for $3 million also grants within the law jurisdiction to the state stolen from a parent who's then required to spend money on child support to the other parent, tax-free money, which then the state can go and ask for more money from the federal government, which we're all paying taxes on. It's hidden taxation. So that's the point I want to make. So in conjunction with the earlier bill that I said, I don't agree with that. An expedient. This one, an expedient. They have the money. They need to look at the fraud that's in the courts. And for instance, the mother of my children's working part-time. She owns her house, most of it. She has far more assets, yet she is collecting government assistance. Her mortgage is less than my rent. And this is not just me. This is many families, mostly men, but then women, when they're less politically connected, or, and I've been working on this for a while, when they don't act like a woman is supposed to, which is docile, subservient. And when a man does not act dutiful like they're supposed to, they get penalized. And then if they don't have lawyers, that's how that works. So again, thank you so much. If there's any questions.
Thank you, Mr. Tanguay. You had checked that you were neutral on this. Would you like me to change that to opposed?
Yes, Senator Carson.
Okay.
Thank you.
All right. Okay, are there any questions for Mr. Tanguay?
Good afternoon. Thank you for letting me speak on this. I'm for this bill. I'm not 100% sure. I actually have some questions for the committee. Okay. Well, it's not, my testimony is that I can't find RSA 490I-1, which is being repealed by this bill. My testimony is in regards to the family courts and the treatment of veterans. This is nationwide, but also in New Hampshire. Obviously, if you're a veteran, we wouldn't have these freedoms if there weren't veterans. What this bill appears to do is create a special court for veterans, given that consideration. I do have some concerns, whereas that maybe if you're a veteran, your ego, but I've talked to most veterans, they realize that they are not better than us. They get special licenses, but they don't have any extra rights than us. So I haven't fully evaluated this bill. However, from my understanding is it's creating a special court for veterans. And I would like to see that because I know a lot of veterans who get used, they have PTSD, and then the other party will say, I'm afraid of them to get a strategic advantage in the family court. These are our veterans that fought for us, or at least risked their lives, or at least made themselves uncomfortable, sweating in a desert somewhere to make sure we can live our way of life. And to put back PTSD, which is able to be handled, and hold it against them, or not acknowledge why, and take away rights in the family court specific, which is my main concern, because that you really don't get a fair shake in family courts. I think that it is a good idea. I haven't evaluated this bill completely, but I think by the sponsors and just reading through it briefly, I think it's a good idea. It's something that we should look at and move forward with. If there's any,
Do you want me to switch it to support from neutral?
yes,
Okay.
I read through it. Thank you.
Do you have any questions? Seeing none, thank you for your
Thank you. God
testimony.
bless. Good afternoon. I might be able to help answer some of the questions that you guys had. I've been following that. And I have 173B, which again is unconstitutional via Article 15 of the New Hampshire State Constitution, rights of the accused. Take away someone's guns with 173B without a trial, criminal convictions. This is all done civilly. And so when you do this civilly, there's no due process. And it's kind of been lobbied by this organization called the Women's Bar Association in the state of New Hampshire. And if you go on their website, the Women's Bar Association's sole purpose is to, I call it gerrymander the family courts, but gain equity for women and families and women and children. That's the specific words. And I put that into a brief at the Supreme Court. So as for the timelines, I do agree with Senator Carson. And as far as the timelines, but maybe I could help explain that a little bit more. When you look at 173B extensions, basically what happens when you get a protection order, even though it's unconstitutional, but let's just pretend it's not, you go and you get an extension. From that point, the defendant gets to rebut that, say, no, I don't want an extension, or just let it be, and then it just gets passed. They always grant the extensions. They grant my extension before a hearing. They grant it, and they didn't even give me the reasons for it. They violated their own law, the court, by not giving me the reasons, and it's just a mess. But so the party, the protected party, would be able to say, hey, this person's dangerous. Then the court decides grant the extension of the protective order or not, deny the extension, and then it's released, and then we're involved with this. I believe, and I don't know if I said that I was against it or for it, but I am for this bill. It's not perfect, however, because it has 173B in there. Again, unconstitutional. RSA 633 is human trafficking, interference with custody. I'm sorry, 633:7 is human trafficking. 33, I think, is stalking, which is just absurd. They're not real crimes, even though they're by statute. So the fail-safe is that the aggrieved party can say, I don't want this, and then the court can say approve or deny it. They pretty much always approve it. They already granted, they approved it because, in my case, because she was afraid of me speaking here. Literally. And I still have to send you guys the actual hearing. So now this bill, which I am in support of, there might be some amendments that you guys can fish through, but it creates a timeline and certainty with the police. They don't want to get sued, but it creates a 10-day timeline in which the Department of Safety must. And then there's an appeal process. Must, shall, must. And so that gives the people back their guns, which are a constitutional right and federally. I don't know the specific statute, I mean a specific case, but this is now recent. It's happening right now. Appealing in the federal appeals court that domestic violence petitions unlawfully, unconstitutionally remove gun rights from people. We can't precog crimes, and we want to prevent crimes, but the real way to prevent crimes is to fix the issues that are involved in our family, in our families, in our communities, that cause people to do crimes. People aren't just crazy. Why does a person steal food? Because they're hungry. And then you can extrapolate from that. So we need to get to the underlying issues. This bill seems to have come in a way where both parties have been, parties, groups, even the coalition, came up with that. So when you're looking at where it's discretionary, the court can at any time say, hey, we got to do a background check. But how likely is it that someone's going to get a domestic violence petition, then get go rob a convenience store, and then with a knife, and then not be allowed to have a gun? I don't know the specifics why you can't have a gun, but just if there's nothing apparent right away, give us back our guns. Another thing that I find is important, and I know I could talk for a while, but I think it is important. I don't know the specific case, but this is recent. Actually, no, I'm sorry. This was in the Republic, Should You Keep It, the audiobook. It's a great audiobook. It's all about the courts from a former federal justice. And he mentioned a case that was absurd, that the person was found not guilty of a crime through appeals, I believe, which prohibited him from having a gun. So it got overturned, the punishment. But because he went out and purchased a gun, the Supreme Court, U.S. Supreme Court, upheld that because he was a felon and couldn't have a gun, even though this other charge, underlying charge, which made him a felon, was overturned, he was still culpable and therefore had a prison sentence. He lost on appeal at the Supreme Court because he knew that, or should have known, that he could not have a firearm at that point. So there's a lot going in there, but this bill, I believe, I just read through it again, and hearing the testimony, I think that we should be able to go through. There might be some minor amendments, but there's all those process. This creates a process for the court, for the person to get their firearms back. And the court can do whatever they want, but they must do A, B, and C, Department of Safety and such. And that's my long-winded testimony.
Okay, thank you very much. Are there any questions for Mr. Tanguay? Seeing none, thank
I
you.
appreciate you all. Thank you.
Okay, are there any other members of the public that would like to speak to House Bill 1339? Okay, seeing none, we'll close the public hearing. Thank you all very much. We've concluded our business of the day.